Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir?
Welcome back to the Courtroom Chronicles, where real justice meets real drama. Today, we're diving into the explosive case of People versus Larry Lee, a defendant accused of trying to strike an off-the-record deal with his own victim. But this isn't just another hearing. It's a high-stakes showdown that could expose witness tampering, legal manipulation, and a shocking twist that leaves even the judge speechless. Buckle up, because this case takes a wild turn when the defendant himself admits to recording his own call. Let's break it all down.
You are all over it. Yes. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasny is the defendant of an AMD against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want to document the potential additional charges. But this all transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one.
Okay. I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's your name?
Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Quasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated.
And there it is. Larry Lee admits to recording the conversation himself. This is the kind of twist you rarely see in court. On one hand, he's trying to prove his attorney was ineffective, citing Strickland versus Washington. That's a real Supreme Court case setting the bar for bad legal representation. But on the other hand, by taking matters into his own hands, he may have crossed a line. Was this a smart defense move? Or did he just hand the prosecution new ammunition? Drop your thoughts in the comments. Would you have made that call?
That he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was.
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorney. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the. I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea. Not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Consley agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
I want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away.
And there it is. Judge makes the call to revoke Larry Lee's bond, keeping him in custody pending further investigation. This case is a textbook example of how quickly courtroom strategy can backfire. What started as a complaint about his own lawyer turned into a potential witness interference case, one that could carry serious consequences. If you found this courtroom moment as shocking as we did, make sure to hit that like button, share your thoughts below, and subscribe for more explosive legal breakdowns every week. Justice never sleeps, and neither do we.
Feast on behalf of Mr. Barrage Scott, who is approaching the podium. Mr. Scott, please state your name for the record.
Dante Scott, sir.
How you doing, Brian?
All right, just glad to see my family in here.
Welcome back to the courtroom, and buckle up, because today's case isn't just about guilt or innocence. It's about trust. Defendant Barrage Scott is back before Judge Simpson, facing serious charges. And this time, the stakes couldn't be higher. After multiple past releases and one shocking arrest just days later, the judge has to decide. Should Scott get another chance, or is this where the line is finally drawn? Stay tuned. This hearing takes a dramatic turn that no one saw coming.
The defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'll be asking this matter be set for the PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond from on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see his prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that His mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks, and he's asking for potential release.
Response.
I would ask that bond remain as currently set. I appreciate Mr. Feaster's advocacy on behalf of his client. I'm struck by the language in the competency report. Mr. Scott affected a volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of severe candidate if you're uncooperative in the underlying competency evaluation. Given his criminal history and the facts of this case, I believe that he is a danger to the community and as
Nothing further, Judge.
All right. I am.
And there it is. The prosecution isn't holding back. By emphasizing Scott's criminal history and the danger he poses, the prosecutor directly challenges the defense's plea for leniency. This moment hits hard because it exposes the core tension in so many cases like this. Rehabilitation versus accountability. The judge's body language says it all. Patience is running thin. You can almost feel the courtroom's mood shift from hopeful to grim as reality sets in.
I'm going to deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters. And typically I can let Mr. Scott out of custody, may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested. So I'm not going to take that chance again, especially since it's
You understand what he's saying to
a violent case.
Hold on, do you understand what he said to you?
So
He said that he let you out. This happened a week later.
I know, but he keeps saying the same thing.
Okay.
The same thing that he's saying.
Okay. I believe Mr. Scott wants to address you directly, Your Honor, if you don't.
Go ahead, Mr. Scott. Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor is saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests, and the first one he just said what he wanted to say. I'm asking if you release me today, because I gotta go see Slay today. They said if I do get released, they're gonna follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I'll be with my auntie, stuff like that. I go to classes. I go to Don Farms. I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. It's my grandma. She's 70 years old, something like that. What it happen if you keep me in here and then she just something happens?
Scott,
No, listen.
Mr. Scott, no, you listen. No, you listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the.
And just like that, Judge Simpson puts his foot down. Bond reduction denied. After giving Scott multiple chances in the past, the judge makes it clear. This court's patience has run out. What started as a plea for understanding ends in confrontation, frustration, and finality. It's a stark reminder that in court, second chances don't last forever, especially when trust is broken. If you found this case as shocking as we did, make sure to hit that like button, drop your thoughts below, and subscribe for more real courtroom breakdowns where truth meets justice and emotions run high.
Oh,
Have you seen it, counsel?
yes, Your Honor, I have seen it.
She's positive for cocaine.
Welcome back to the courtroom, where second chances meet hard consequences. Today's case is the People versus Molly Fox, a mother of 3 fighting to keep her freedom after testing positive for cocaine. Again, her lawyer says it's an anomaly, the judge isn't buying it, and tensions are rising fast. Will compassion or accountability win in this courtroom showdown? Let's break it down.
Right. Your Honor, when the bond was set, I wasn't actually present when the bond was set, but at that point, I think they all agreed that her major problem was that alcohol. That was why she entered a recovery program through community corrections. And she's also been attending AA. Now, she's not been positive as I understand it, she's not been positive for alcohol use since that time. This cocaine use is kind of, I don't know, an anomaly. And it seems from my discussion with my client, it's kind of situational, and she realizes that this is absolutely unacceptable.
She had another anomaly back in March.
Right, I understand. But what I mean is, it's not, unlike the alcohol, it was not the dominant problem. And yet it is a problem, of course, but it stems, I'm told, from a friendship that she has with somebody that she's had for many, many years. And apparently this other person got into cocaine use, and she would sometimes participate when she was with that person. She realizes she has to break off all contact with this friend because it's apparently evolved into a relationship in which cocaine is customarily used. So we would ask, of course, that bond be continued, and if court thought it was appropriate, she could be put on a tether. She has been going to, she had 8 weeks of first phase recovery program, and she'd started the second phase prior to this cocaine use. And she also has been going to AA once a week in addition. So the recovery program, I guess I would have to say, has been partially successful. And we would like to have an opportunity for her to continue to work on her recovery through that. And I know Mr. Kennedy and I have talked about possibility of resolving the case through recovery court, but he's not sure that she's eligible. And I've been waiting to find out if that's true, because that might very well be a good resolution. So, and in the meantime, I mean, she is the caregiver for three minor children, ages 10 and 5. They're all her children. And her significant other with whom she lives, he works full time for one of the car companies, I forget what one, for Ford, and is gone in the daytime. So caring for the children, especially when school gets out, which will be pretty soon now, would be very difficult without her presence. But so of course, we're asking for bond to be continued or possibly be modified to provide for her to have an alcohol drug tether. I might also say, I think my understanding is that she entered the recovery program voluntarily. That was not a bond condition. Is that correct?
It wasn't.
She says it was not. So she's attempting to do recovery on her own, but of course, community corrections made it possible for her.
Violation with cocaine.
I'm sorry.
This is her third violation with cocaine.
The judge's response is sharp and, frankly, justified. When the defense suggests a tether to monitor cocaine use, the judge cuts in, reminding everyone that no such device even exists. That's the legal reality. While alcohol monitors are common, there's no reliable tether for drug detection. The judge also calls out a crucial point: Molly's pattern of dishonesty. 3 violations, 3 warnings, and now the same excuse. This moment reveals the court's growing frustration. The question now is, has Molly truly learned, or is this another empty promise?
Apparently so.
Yeah, that's a problem.
It is a problem, but I think a tether would definitely take care of that problem.
I don't have a tether that reads cocaine.
Well, that's what I wasn't sure when she suggested it, whether that was feasible. She seemed to think it was, but I don't know.
She who?
My client.
Of course. She's going to tell you that, and then she's going to go out and use cocaine.
Well, maybe she just doesn't know. I didn't know.
She does what drug addicts do, and they tell you something that's not true.
Well, I don't know that she's truly an addict because her use has not been that frequent. But at any rate, I totally agree with the court that she can't be using cocaine, and I think she also agrees, and she understands.
At what point did that dawn on her?
I'm sorry?
At what point did that dawn on her? When we ordered that she couldn't use illegal drugs? In January when she tested positive? In March when she tested positive? Or this time when she tested positive? Which point did she all of a sudden figure out she can't use it?
Well, she should have figured it out beforehand, Your Honor, but she now tells me she has figured it out, I guess you could say.
I always hate asking, but I'll ask. Why not? I'll bite. What this time made her figure it out?
Well, maybe she's come to a realization that it's not a good thing for her. I mean, she's brought it up in the group sessions that she's had, these weekly group sessions, and I think they've convinced her that she has to cease her friendship with her old friend because obviously it's not a friendship that's furthering her best interests. And she tells me that she is going to do that. So I hope that she has come to a realization of how damaging to herself that this is.
I'm going to adjourn the probable cause conference in this case to June 5th, 2025, 9 a.m. Because of her violation, defendant's bond is revoked, defendant is remanded.
Thank you, Your Honor. That's it for me today, Your Honor.
Take care.
Yeah.
Happy birthday.
Thanks, sir.
In the end, the judge revokes Molly Fox's bond, sending a clear message. The court may offer help, but it won't tolerate repeated violations. Despite her efforts at recovery and family obligations, the law demands accountability. This case is a powerful reminder. The justice system balances compassion with consequence, but that balance only holds when honesty stays at the center. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Justice isn't always gentle, and here it wasn't forgiving either.
Kamara Reed, she's stepping forward.
Go ahead.
Your Honor, Ms. Reed is here, I believe for a pretrial and a bond violation. In however order Your Honor would like to proceed, she will be admitting to the bond.
Welcome back to the courtroom, where second chances and hard truths collide. Today, we meet 21-year-old Kamara Reed, a young woman standing before Judge West after admitting to operating while intoxicated and violating her bond. But behind the charges lies something deeper, a story of grief, loss, and redemption. As this emotional hearing unfolds, we'll witness a powerful exchange between law and compassion. Will the judge show mercy or deliver a wake-up call she'll never forget? Stay tuned.
You swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Tamara Reed.
All right. Ms. Reed, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. Is that correct?
Yes.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Understand that?
Yes.
The court could also order any community service or rehabilitative service if the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that? Yes?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
She didn't, Your Honor, because she's in custody. I could have her do that now, or we could do that verbally, however you prefer.
Okay, you recall signing an advice of rights form, ma'am?
Yes.
Any questions regarding any of those rights?
No.
You'll see on the podium, I need you to look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
November 27th, 2024, location of Carpenter near Chester Drive in Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
All right. Prior to operating that motor vehicle, did you consume intoxicating?
Yes.
What did you have and how much?
I had a couple of seltzers.
Seltzers? All right. Were you stopped by the police or was there an accident?
I was stopped by the police.
Why'd they stop you?
My lights were off.
All right. Were you ultimately arrested?
Yes.
Were you taken to the station?
Yes.
Was there a blood draw or a blood test?
Both.
Blood draw?
Yes.
All right. What were the results of that blood draw?
I would stipulate for the plea, it was a .09 blood test.
You have any reason to dispute those blood test results?
No.
No? All right. I do have to advise you that if I do accept your plea, if you commit misconduct between the time of my acceptance of the plea and the time of sentencing, that any evaluation or sentence agreement, the court would not be bound by. You understand that?
Yes.
I also would have to indicate that if you do commit misconduct during that period, you would also not be entitled to withdraw your plea. You understand that?
Yes.
Counsel, I guess the first question is, have there been any promises, threats, or other inducements which have led to this plea which have not been stated on the record?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Your Honor, I would say for the record, just so it's clear, the stop happened just after midnight. So the stop for no headlights is a valid stop. I think that they would stipulate that it was dark outside.
I don't.
Other than that, I'm satisfied.
We're satisfied as well, Your Honor.
All right. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be July 9th, 2025 at what time? 9 a.m. All right. Either as to bond, but as to the violation.
For the violation first, Your Honor, my client would waive her right to a hearing and be prepared to admit to drinking and ready to do that this morning.
All right. And that is correct, ma'am?
Yes.
You're waiving your right to a hearing?
Yes.
And you do admit, have you seen the violation report, ma'am?
No.
Okay, your counsel went through it with you, however?
Yes.
All right. And that there were on June 13, 2025, that you were drinking?
Yes.
Very good. Court will accept that admission. How long have you been in?
She turned herself in yesterday morning. Is that what time yesterday?
8 a.m.
8 a.m. yesterday morning.
All right. How old are you, young man?
20,
How old are you?
21.
Where were you drinking?
Um, um, sorry. My dad passed away a couple of years ago. My dad passed away a couple years ago, and I'm not handling it probably in the best way.
This moment changes everything. What began as a simple DUI plea has just turned into a raw confession about grief and trauma. Kamar reveals she's been struggling since the loss of her father at just 18. And suddenly, this isn't just about alcohol or poor judgment. It's about pain. Notice how Judge West slows down, softens his tone, and begins to connect personally. In courtroom after courtroom, we see this same battle, law versus empathy. And here, empathy wins. What would you do if you were in the judge's shoes right now? Comfort her or keep the focus on accountability?
You were 19,
18.
18 when he passed away.
Yeah.
Let me ask you this, was that where your drinking started or?
Yes.
And let me ask you this, I'm not gonna hold it against you, were you drinking a lot?
Yes.
Looking back on it, when you were drinking a lot, what do you think would happen for you? Probably don't know how to answer that question. I mean,
Yeah.
that's a tough question, isn't it? Suffice it to say, young lady, it would kind of make you forget and have the pain go away a little bit, right?
Yeah.
Okay. So, are you in school?
Yes. I'm
Pardon?
supposed to go back next semester.
Did you finish up this semester?
No.
What happened?
Um, I stopped attending my classes, so I had to withdraw.
Where were you in school?
It's my sophomore year,
At what school?
Eastern Michigan.
So when your dad passed away, had you already enrolled in school?
Yes.
And you made it through how many semesters after that?
2, and then I took a gap year, and then I went back.
Those 2 semesters that you took, how were your grades?
They were pretty good. I think I had a 3.2, 3.5.
Okay. You took the gap year, then you came back. How were your grades?
Okay, I think I had like a 2 point.
Pardon?
I think I had a 2.8 when I came back.
Where'd you graduate high school?
In high school.
Okay. Did you do well there? You got siblings?
I have a twin brother.
You have a twin brother.
Yeah.
Okay. What?
It's with mom in the corner of the courtroom.
Mom's on? Oh, okay. All right. So what do you think I should do with you? Well, before you answer that, let me ask you this. As you were going along struggling, trying to deal with your father's passing and things, did you let your mom know?
A little, but
Pardon?
a little, but not as serious as it had gotten. I don't think.
What about your brother?
I think he noticed.
You think he noticed?
Yeah.
Probably because he's your brother and also a twin, he probably did, probably felt it. Did you reach out to anybody?
I've been seeing a therapist weekly.
You were?
Yes.
Okay, so how long have you been doing that?
I was seeing one I've been seeing her for like 7 years, and then I've been seeing one who specializes in grief for the last 3 months, I think.
Okay, so something that you started heading in that direction, dealing with her. Okay. How's that working for you?
It's going okay. I think I've been thinking about seeing someone else.
Pardon?
I've been thinking about seeing someone else. I don't know if it's a good fit.
Okay, so your therapist might not be fitting with you, right? Okay. All right. Now I'll get back to what do you think I ought to do with you?
Sure, I guess whatever punishment fits.
Give you a chance to prove you can stay sober.
Yeah. A chance to prove I could stay sober, I think.
You think you can?
Yes.
That wasn't real confident the way you said that.
I want to, and I think that I can.
Young lady, why do you think I asked you all of those questions?
See why I did it, I guess.
Yeah, maybe. Here's the thing that you don't understand and are just beginning to kind of explore. Grief is a horrible thing in a lot of ways. It becomes real bad if you don't deal with it. It kind of just sits there, and then at some point, while you try to sort of bottle it up and push it down, it somehow or another just all of a sudden begins to explode. Right? And then at some point, because you're not dealing with it, you're kind of out of control. And then it becomes harder. At the beginning, you probably could have told somebody, but by that time, you don't tell anybody because it becomes hard to explain. Right? And it becomes real difficult to, no matter how close somebody is, even talk to anybody because you don't know if they're going to listen or they're going to have time to listen. And the reality of all of that is what you want is you just want that hurt and other things to disappear. Right? Were you close to your dad?
Yeah.
Something's going to. I'm going to guess, but I know I'm right because I'm always right. But I'm going to guess that you were daddy's. All right. Look, more than anything, and I'm going to tell you, I don't always talk about myself, but I'm going to tell you why I asked the question. Here I sit all these years later. I lost my dad when I was 16. So when I'm asking you those questions about grief, I get it. Okay. I'm going to let you know that if you find a way to kind of deal with it, you're going to make it through it. Okay. I didn't know your dad, but I can almost bet that he'd want you to make it through. He wouldn't want you trying to do this, trying to deal with all of this on your own. Okay. So in the interim, how am I going to keep you sober? Young lady, there's just right now, and partially because of the age you are, partially because of what you've been dealing with, a lot of things in life are real confusing right now, right? You're not sure the next step that you're taking, what direction that's going to head or what you're going to do, right? Okay, here's a suggestion I'm going to make to you. I want you to take whatever steps you're taking slow. I'm watching your mother over there. She's goosenecking trying to look over Miss Pilara's head, but your brother has been right all up in it. Okay. What that tells me is you got a family out there that'll just love you, they'll support you. And if you hadn't told them, probably after today, they'll sit for whatever time and just listen to you. Okay. And as you let it pour out to them, and I'm going to tell you, it's going to come out wrong. It's going to come out crazy. You may think yourselves crazy as it's coming out, but just let it come out. Okay? Here's what I'm going to do. I indicated defendant is admitted to violation. I don't think it does any good to keep you incarcerated at all. All right. So I'm going to sentence you on that violation to 2 days in jail, credit 2 days use. I'm going to let you go. You are going back to school in the fall. That might have sounded like a question. It wasn't. Okay. And that you can take that as an order. You're going to go back. You're going to just sort of walk that journey through life and do that. Okay. You hear me?
Yes.
And I'll sign that scram order and we'll get you over there. All right, young lady.
What an extraordinary hearing. Instead of harsh punishment, Judge West chose compassion, giving Kamar credit for time served and ordering her to wear a monitoring tether while returning to college. His words weren't just legal instructions. They were life lessons about healing, accountability, and self-forgiveness. This case reminds us that sometimes justice isn't about punishment. It's about helping someone rediscover their path. What did you think of the judge's decision? Too lenient or exactly what she needed? If you found this case as powerful as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more real courtroom breakdowns, legal insights, and stories that stay with you long after the verdict. Welcome to the courtroom, where remorse meets reality. Today, we're diving into People versus Jessica Duff, a shocking DUI case that left one woman permanently scarred and another fighting for redemption. The twist? Jessica claims full responsibility and even brings restitution in cash. But can money ever heal what's been broken? Stay tuned, because this case will test your sense of justice and forgiveness in ways you won't expect.
I'd like to make the statement. All right. Go ahead, just have it.
Good morning.
State your name, please.
My name is Amy Hudson, AMEE. Last name's Hudson, HUDSON.
All right, go ahead.
So on August 31st, you changed my life forever. You made the decision to get behind the wheel of a car drunk. You drove into the back of my car. I was sitting at a stoplight. Not only did you drive drunk, but you were speeding. I will never forget the sound that haunts me to this day. By throwing me around in the car like I weighed nothing after the pressure of your vehicle blew out the back tire sitting in the driver's seat, which broke, by the way, along with the seatbelt. The airbags burning into me and the pain. I honestly don't remember much about getting out of the car, except for the look on the passerby face. The driver's door was broken. It took both of us to get me out. He stood there with tears running down his face, telling me not to swallow due to the blood pouring from my mouth and face. From my nose and mouth, excuse me. The pain from my left side and hip was worse than pain I'd ever described, that I could not even realize I was bleeding, burned on my elbow. My left hand was completely damaged. I ended up going to the same hospital, to the same ER as you. You did not know it, but I was in line in front of you. As I cried in pain, I listened to you laughing and joking with the officers. Not once did you ask about the other driver or what you did or what was going on. There was no remorse. For nearly 7 weeks, I was on crutches. This did not include the 7 days beforehand that I was completely bedridden. I cannot drive past that street without shaking. If someone comes up behind me too fast at a stoplight, it's hard for me to even breathe at times. You did this to me. You made the choice to drive drunk. The permanent effects from this vehicle accident that I have to live with the rest of my life, just to state a few. I have permanent scars from the burns from the airbags. I will never get to feel what it feels like to put a ring on my wedding finger again. It is damaged to be unfixed. I walk with a limp. I have permanent damage done to the side of my face, to the right side of my face. I have permanent damage done to the left side of my whole body that will never be able to be repaired. After grueling months of physical therapy, which I'm still going through, multiple surgeries, I will never get any of that time back. The only income that came out of this was that I learned one thing about the justice system, and that is that they're not always your friend. The victims are the ones that pay, and the criminals are the ones that are made to look like the heroes. I have fought every single day for my voice to be heard. I have fought every day for the insurance companies, for justice to be served as today, and for you to be sentenced for this. I am asking for the court to give you the highest recommendation can be, including having it be to where anytime you get into a vehicle, you have to blow. I'm also asking for the restitution, which does not even cover half of what I've lost or what I've had to pay for. It's only for what I could find the receipts for of the rental vehicles and for the towing, which is $2,700, I believe $40.21. Thank you.
Well, first of all, I have $2,720.80.
I did not have the amount in front of me.
Oh,
Is the reason why I was saying that. I did not have that. And that does not include, that's only the receipts I could find of the rental. I had a loaner vehicle. So that's what I was driving. So while the insurance companies were fighting, I had to rent a vehicle until he could get his money back. And then he proceeded to work on my vehicle. So but that was.
are you telling me that there's additional restitution?
Yes, there is, but I'm not charging for that because I could not provide the receipts. I only had until May 7th. And unfortunately, one of the places that I rented the vehicles from closed their doors at the end of last year. So I was not able to get the original, the receipts for that one.
Okay. All right.
Thank you.
Your Honor, if I may, I'd like to make a direct apology to Ms. Hudson.
You may.
May I turn and face her?
Okay.
I'm so sorry. I'm so sorry. I take full responsibility. And I'm so sorry for the damage that I caused to you and to the hurt that I caused to you. If I could take it back, if I could undo it, I would. I would completely undo it. I will never do anything like this again. I'm sorry.
Thank you.
Jessica's apology sounds sincere, but let's be honest, remorse often arrives when consequences do. Still, this moment is critical in court. A defendant directly facing her victim and owning her actions. That can influence sentencing more than most realize. Judges look not just at what happened, but who you are after it happens. Yet, as we heard from Amy, no apology can reverse lifelong injuries. So, what do you think? Is remorse enough to outweigh the damage done?
I appreciate that. Thank you.
And is there anything you want to tell the court before I impose?
Same, Your Honor. Sorry, and I'm deeply regretful. I've learned from this. I think about this every single day. I do have complete remorse. I do have complete regret. And I intend to never repeat anything like this experience again.
This is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, AA meeting attendance, and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court, I will place you on 18 months probation. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $540 probation oversight fees, $2,720.82 restitution that is payable to Amy Hudson, but that is payable through the court. What can you pay today?
We're prepared to pay that in full today.
Pardon?
We are prepared to pay in full today, Your Honor.
Everything today?
Yes,
All
sir.
right. And you do have then the restitution in cash, correct?
Yes, sir. We
Okay, very good. All right. All of that is payable today. There is to be no use of.
And there it is, justice with compassion. Judge grants probation over jail time, citing rehabilitation and Jessica's compliance with treatment. The restitution, over $2,700, is paid in full on the spot, a rare moment of accountability. Still, it's impossible to ignore Amy's pain and the lifelong reminder of one night's mistake. This case forces a difficult reflection. Can true justice exist when the scars remain permanent? If you found this breakdown as powerful as we did, make sure to like, share, and subscribe for more real courtroom moments that challenge your sense of right and wrong. And tell us in the comments, did the judge get it right?